Good morning, everyone. Welcome to Class 27, our discussion of citizenship and immigration. Will be the last substantive lecture for this week because Friday we'll be having our current events Friday, so there won't be a lecture for you all to watch for Friday. So let's go ahead and jump right into today's topic. So today we're going to be talking about the process of immigration and naturalization, but also how how immigration policy and processes have changed over history, and looking specifically at some changes in the 20th and 21st century. These are detailed in May 9's piece that you all were supposed to read for today. I understand that piece is a little bit complex, so I'm going to try to simplify some of those changes and discussion in this lecture. So we can start with the idea of what it takes to be a citizen in the United States. Now, the 14th Amendment to the Constitution states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens in the United States and of the state wherein they reside. And this amendment kind of sets out the idea of citizenship in the United States on two pathways. The first, and then these citizens enjoy certain rights. These are not explicit in the Constitution, but these are the rights to reside and work in the United States, to enter and leave the country's borders, to vote, to stand for office, to apply for federal employment, and also a series of duties, including jury duty, military participation, whether in an active draft or participation in the selective service, paying your taxes. Now, non-citizens are also responsible for paying taxes. Non-citizen residents pay taxes. However, citizens who reside abroad are also liable for certain taxes and participating in the U.S. Census. Now, one avenue of citizenship is birthright citizenship. This is the all persons born in the United States. And this means two ways. That first of all, anyone who is born in the United States, and Congress made this explicit to extend to the territories, even though they are not states. With the exception of children of wartime enemies and foreign diplomats, are automatically guaranteed citizenship. That if you are born on U.S. territory, you are guaranteed citizenship, regardless of the citizenship of your family. Now, and then persons born to U.S. citizens abroad, with some exceptions and exclusions. But if your parents are both citizens, you are also a citizen. And there's more technical details and exclusions that aren't really, we don't need to go into further detail here. But it also sets up this idea of naturalized citizenship in the United States. So here we're talking about people who are not born citizens. You're not born an American citizens, but become American citizens through processes of naturalization. So how does this work? First, you have to be eligible for naturalization, and there's a series of requirements. First, you must be a legal permanent resident. This is also known as called LPR. These are people with green cards. These are people who have legal permanent status but are not citizens. There are a series of various non-permanent immigrants and non-permanent residents, or permanent residents without legal status. According to the way that the citizenship laws work now, they are not eligible to be citizens. You also have to be in residence in the United States for 5 years, or this is limited to 3. This is lowered to 3 if you are married to a U.S. citizen. And there are various restrictions on overseas travel. You can't have spent more than a year abroad consecutively during that 5 years. There's limited on a number of times of trips you can take, but the idea here is that you've actually established permanent residency in the United States. That you need to have basic knowledge of English and civics. You have to pass the citizenship test. You have to establish good moral character, and we'll talk a little bit about this when we talk about some of the qualitative restrictions on immigration broadly, but you have to you can be excluded from citizenship if you are deemed not to have good moral character. You have to be able and willing to serve in the armed services or civilian duties if that is required to you. There are certain exceptions that can be made in this process. And you have to be you have to pledge to support and defend the Constitution and be willing to take the oath of citizenship, which is the last step of the process. So this process itself, more bureaucratically, begins, like all things, with the submission of an application that proves your eligibility and pays a fee. You then have to offer proof of your identity. This involves a biometric proof. Then you have to conduct a naturalization interview with a government official in order to both establish the veracities of your claims. This is a lot of times where the good moral character comes in. Especially if you're applying for citizenship with this 3-year requirement based on your spouse's citizenship status. Over here naturalization interview is also intended to prove the veracity of your relationship. You also then, if your naturalization is approved, you are then scheduled to take the oath of citizenship. You surrender your green card, and you take the oath of citizenship, and you become a full full citizen of the United States. Now, often when we talk about citizenship in the United States, this is bound up with the question of immigration. And so the Constitution, and if you're interested in this process, there's more information I've linked here to the USCIS website that talks about it gives like an overview of the naturalization process. So, like I said, this is bound up with the question of immigration, and this authority is explicit in the Constitution that Congress in Article 1, Section 8 of the Constitution has the authority to establish a uniform rule of naturalization. So Congress has the right, and the Supreme Court has upheld the right in various cases, including a recent case, Arizona versus United States, that ultimately it is Congress and not the states that establish immigration and naturalization policy. This has been reinforced through what's known as the plenary powers doctrine, and we talked about this a little bit. We talked about the balance of power. This really comes out of both the Xi Jinping versus United States and other Chinese exclusion acts. The Xi Jinping case involved a challenge. Involved someone who obtained an official document, a Chinese national who obtained an official document who was residing in the United States and received permission to leave the United States and re-enter the United States with an official certificate. But an amendment to the Chinese Exclusion Act was passed that pretty much became an ex post facto law and prohibited Xi Jinping from returning to the United States. There was a lawsuit, and the Supreme Court ultimately held that the political branches of the United States, the legislative and the executive branches, should be deferred to with respect to regulating immigration. They argued that the regulation of immigration is an inherent power of the federal government and outside of constitutional review, and that this was the court basically declared that from May 9th piece, that aliens have no right to be and remain in this country except by the license, permission, and sufferance of Congress. So this court decision really established, and these other court decisions ultimately established the unquestioned authority of the federal government to regulate immigration. Now, this has taken a variety of forms throughout the history of the United States. As early as 1790, the Naturalization Act of 1790 limited naturalization to free white persons, and this was only expanded to include blacks in the 1860s and Asians in the 1950s. And this actually made the United States an outlier in that. It was a race-based distinction of immigration that was an outlier for other countries at the time. In the early years of the United States, immigration was relatively low, fewer than 8,000 people a year, and then this kind of increased over the course of the time, such that between 1836 and 1914, over 30 million Europeans migrated to the United States. The first formal immigration law was the Page Act of 1875, named after its sponsor, Horace Page, in Congress, a representative in the House of Representatives. And this was targeted, this established a series of qualitative restrictions based on what were deemed to be undesirable immigrants, and it was specifically targeted at Chinese laborers. Horace Page introduced the bill to, quote, end the danger of cheap Chinese labor and immoral Chinese women. It included specific prohibitions about both forced labor, with the idea that it would crack down on Asian immigrants who were deemed to be brought here without their consent, and in an attempt to lower the amount of cheap Chinese labor in the Western United States. And specific targets against prostitution were viewed as a specific, basically led to a de facto exclusion of Chinese women. This also is where we begin the kind of sexual policing of immigration, which continues to this day. The Page Act was expanded in the Chinese Exclusion Act of 1882, and this prohibited all immigration of Chinese laborers. That this was a de facto ban on, or a functional ban on all Chinese immigration. And this was the first law that implemented to prevent all members of a specific national group from immigrating. And this was originally intended to last only 10 years, but was then expanded. And there were a series of amendments to this law, and it was over this law again that the Xi Jinping brought suit against the United States, and the kind of doctrine, the Supreme Court of the United States Congress to regulate immigration and control access to its borders. Now, as you noted, you probably remember from reading the Nye piece, the kind of focus of immigration changed in 1924 with the Immigration Act of 1924, which introduced the idea of quantitative rather than qualitative restrictions. And here the idea was less about policing the quote-unquote desirability of immigrants, but setting numerical quotas here, so that it was less of a question of verifying, of determining who would be allowed in on various qualitative characteristics, but basically saying, are you under this quota or not? And so the total quota set by the law was 165,000 for countries outside of the Western Hemisphere, which was an 80% reduction from the pre-World War I average. There were also national quotas that were set based on 2% of the U.S. population from that country, as recorded in 1890. And the idea here was these national quotas, and each nation would be allowed to have immigrants numbering in 2% of that nation's representation in the U.S. population. So this basically created a kind of freeze on the distribution of national origin in the United States population, and this also was significant because it included expanded enforcement capacity. One of the big ideas here was that it expanded the ability of the Border Patrol to enforce immigration restrictions, and this made it expanded the authority and speed in which deportations happened. And as Nye notes in the piece, that this created the legal category of the undocumented immigrant. These would be people who immigrated to the United States but exceeded the quota, either the total quota or the quota for their national origin, and they were excluded based purely on these abstract and numerical categories, not because there was any sort of qualitative reason to prevent their entry. It wasn't because there was any sort of concerns about their education or skills or moral standing, that there was purely this kind of like abstract exclusion based on a numerical limit. But this created, as Nye notes in the second half of the article, kind of a strange effect here, whereas it created a backlash in which many immigrant communities, especially of European descent, tried to challenge the Immigration Act of 1924 and gained several exceptions to these national quotas to prevent deportations based on certain like outstanding extenuating circumstances and based on family ties. But as Nye notes, that these same types of exceptions and extenuating circumstances were not granted to immigrants from Mexico, and this created this like division between European immigrants and Mexican immigrants, and created this kind of fusion of immigrants from Mexico became kind of in the national consciousness and legally kind of associated with the category of undocumented immigrant, where immigrants from Europe, even immigrants from Europe without proper documentation or regular migrants, they were viewed as these deserving immigrants and were granted exceptions. And so this, even though this that this wasn't explicitly in the law, it became how the law was implemented and enforced. Now, this was changed in 1965 with the Immigration and Nationality Act of 1965, and this replaced national quotas, these 2% quotas, quotas that were based on 2% of the population, and replaced them with a series of immigrant categories, but preserved a per country and total cap. And we'll talk about these in a little bit. But these quotas weren't based on the national origin to try to maintain the kind of the balance of national origin in the United States population. But there were different caps based on the number of immigrants, the total number of immigrants available. And so the Immigration prioritized specialized skills and employment-based visas. These would be visas, and we'll talk about these in more detail in a second. But these were visas in which you were sponsored by your employer, but it also included exemptions for family members. While there were retained certain caps on the total on immigration, that if the spouses of American citizens and many immediate family members of American citizens, there were particular exceptions. This also created for the first time, limits on immigration from the Western Hemisphere. If you remember that this immigration quota from the Act of 1924 was specifically for the non-Western Hemisphere, and now in the 1965 Immigration and Nationality Act, we have a shift to creating specific limits for the Western Hemisphere, and this also added a labor certification requirement that for what was deemed as unskilled labor immigrants had to require specific certification by the Secretary of Labor that there was a labor shortage. Other than that, the only way that you can get an employment visa in the INA was based if you had specialized skills or had professional degrees. So how do these immigration restrictions then work? Well, there's two types of restrictions that still are in effect, right? That we still have quantitative restrictions, and there are 675,000 permanent immigrant visas available that are divided into different categories. However, visas for spouses, unmarried minor children, and parents are exempt from these limits. So there is a quantitative cap, but it is unlimited for immediate family members of American citizens. In addition to this overall cap, there is also a 7% per country cap. And the idea here is that no group of permanent immigrants based on family and employment-based immigration from a single country can exceed 7% of the total number of immigrants. So the idea here is to provide a certain amount of fairness. Now, this is very different from the national quota system. This is not trying to maintain existing balance, but it's saying that no one country can make up more than 7% of the total immigrant pool. But the Section 8 of the INA also includes a series of what they note as conditions of inadmissibility. Which maintain qualitative restrictions on immigration. These include certain restrictions based on health to prevent the spread of communicable diseases, criminal convictions, both of crimes of moral turpitude. Here, these are specifically crimes of prostitution are singled out, and other sexual offenses, as well as crimes that involve the violating laws about controlled substances. There are specific restrictions on security. People who, and these are pretty much terrorists, communists, and other totalitarians. So members of the Communist Party are inadmissible for permanent immigration. The fourth is likely at any time to become a public charge. So the idea here was that the idea behind public charge restrictions is to declare those who would become dependent on social services inadmissible for immigration. They also created, if you were an unskilled laborer, quote unquote, you were inadmissible without certain exceptions from the Secretary of Labor declaring that there is a labor shortage. Aliens present without admission or parole. And the idea here is that you are not eligible for a permanent immigrant visa to get a green card under the INA if you are present in the country without lawful admission or granted a parole status. So that's the idea here. And this is why in many discussions about undocumented immigration today, there's the idea of creating a pathway to citizenship. Because if you remember, you cannot become a citizen without first having LPR status, this legal permanent resident status. But the INA specifically says that if you are illegally present or unlawfully present in the country, you cannot gain lawful permanent resident status. And so there's no pathway to citizenship there. If you lack the required documents, you can be inadmissible. If you are ineligible for some reason to become a citizen of the United States, you can be denied immigration status. Or if you were previously removed from the country. So if you were previously deported from the United States for unlawful entry, you would become ineligible for a permanent immigrant visa. There are also a series of other criteria, including practicing polygamists, and those engaged in child trafficking are also deemed inadmissible for a permanent immigrant visa. Now, there's a series of different types of visas. Like I said, these family visas for the spouse, for the spouses of citizens are unlimited. There are also 100,000 visas given out for particular family members of American citizens, and another 100,000 visas given out for family members of those with legal permanent residence. So if you have a green card, you can also get your green cards for your family members. And these family-based visas account for about 2/3 of all visas that are given out. In addition, there are a series of employment visas that go in a tier of preferences. So these EB1 or E1 visas are the highest level of priority, and they go down from here. So the first priority are people of extraordinary ability is the language that the law uses, and these are people who are likely to make a significant contribution. It actually singles out the arts, athletics, but also like scientific and research discoveries. Then people with advanced degrees or any unused or any overflow from this number. So these numbers are intended to overflow down the number here. And then it goes to people with college degrees or other sort of professional skills that are deemed they're sponsored by their employers. Then it goes to special immigrants, and this category focuses most primarily on religious categories. And then the EB5 visa, which are those who are able to invest between $500,000 and $1 million in the creation of a company that would then employ 10 full-time U.S. workers. This is the if you have enough money, you can buy a visa. There are also a series of categories of special visas, and these are the SIV and SQ visas are visas that are the SQ was a former program that granted special immigrant visas to Iraqis and Afghanis who supported the U.S. government during the U.S. wars and occupation in those countries. The SQ visa gave 5,000 visas per year, but up until 2014, and then it expired. The SIV program gives, which is still in effect, the SI visa gives 50 visas a year to specifically marked out for translators in Iraqi and Afghani translators, but it's only 50 a year. Then there are 55,000 diversity visas, and these are randomly allocated to nationals from countries that have sent fewer than 50,000 immigrants to the United States in the previous 5 years. And these are randomly allocated. This is when people talk about the visa lottery, this is what visas these are referred to. But outside of these categories and a few other special categories, there is not really any other pathway to getting a green card, a legal permanent residency. So in addition to being under the quantitative requirements and passing all of the and avoiding all of the conditions of inadmissibility, these qualitative restrictions that were on the previous chart, you also have to either have a family sponsor or an employer sponsor, or fit into one of these, or get lucky with a diversity visa. So the process of getting a visa is severely restricted, even in this world of quote unquote legal immigration. It's also important to distinguish those types of immigrant visas versus refugees and asylees. So refugees are persons outside of his or her country of nationality who is unable or unwilling to return to his country of nationality because of a persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So this is the idea that you are at a well-founded fear of persecution and you are fleeing your country of origin based on some sort of protected status, based on your race, your religion, nationality, particular social group, or political opinion. You are then required to apply for lawful permanent residency status 1 year after being admitted. Asylees are a person who meet the definition of a refugee and you are already present in the United States, or you are seeking admission at a port of entry, and then you may apply for a green card status a year after being granted asylum. Now, there are still quantitative and qualitative restrictions here, and there are various caps on the number of refugees and asylees. In 2019, that cap was at 30,000. As we'll talk about for 2020, that cap fell even smaller. There are also regional limits on different regions have different specific limits in order on refugee admissions. But the qualitative restrictions here are also note. This idea of a well-founded fear based on race, membership in a particular social group, political opinion, religion, or national origin. This became under scrutiny in previous years as the Trump administration, then Attorney General Jeff Sessions, basically argued that gender did not count as a particular social group, and that this created an enforcement immigration policy in which fear of sexual abuse and fear did not count for a well-founded fear for refugees and asylum seekers. And so there's how this well-founded fear gets interpreted is up to DHS officials. You have to pass this credible threat interview. So there's all sorts of discretion here in actually granting admission based on refugee and asylum status. So additionally, your supplemental reading for today also talked about differences in immigration federalism. And here the idea is that while we often focus on the level of the federal government, because the Constitution and the Supreme Court have upheld the federal government as the primary kind of locus of immigration authority, your reading also focuses on how there are distinct measures at the states. So on the one hand, since 2001, we have seen increasing restrictions at the state level. These include Arizona's SB 1070, the Show Me Your Papers piece of legislation that allowed for law enforcement officials to basically search anyone on the street and demand to see their proof of legal residency. But these also include increased enforcement of E-Verify, so penalizing private businesses that don't use the E-Verify program system to validate immigration status and work status, prohibition of sanctuary policies at the city level, and denial of in-state tuition for undocumented immigrants. But at the same time, in more recent years, since 2012, the authors note, there's also been some states, and these differences between what they call the Arizona package and the California package. They differ on party grounds. That blue states tend to have looser restrictions, and red states tend to have increasing restrictions. These include sanctuary cities and states, so states and localities whose law enforcement refuse to cooperate with DHS and ICE on collaboration out of fear of deportation. And additionally, these also include a package of membership rights, even without formal immigration status, including in-state tuition, including access to certain social services. So while immigration policy is set at the federal level, there are significant shifts at the state-by-state restrictions. But probably since 2016, what most people think about immigration reform is various actions taken by the Trump administration. In January of 2019, 2017, one of the first actions taken as president, Executive Order 1370 13769 banned the travel from a series of Muslim-majority countries. And the original 7 were Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. And this meant that more than 700 travelers were detained and 60,000 visas were provisionally revoked. This was expanded in January to include Nigeria, Eritrea, Tanzania, Sudan, Kyrgyzstan, and Myanmar. Now, this was challenged in a series of court cases, but eventually the Supreme Court in 2018 decided in Trump v. Hawaii that they held that that this executive order did not violate either the statutory authority given to the executive branch under the Immigration and Nationality Act or the Establishment Clause of the Constitution. And so they argued that under the INA, the president has broad discretion to suspend the entry of non-citizens to the United States, and that the proclamation was the result of a worldwide multi-agency review that determined that entry by certain non-citizens would be detrimental to the interests of the United States. So they argued that this is a continuation of the plenary powers doctrine from Xi Jinping, and basically upheld that the presidency has more or less unilateral authority to under the INA to pass restrictions on immigration and entry to the United States. Additionally, there was the zero tolerance policy of the Trump administration which called for the immediate deportation of individuals for illegal entry prior to their having a immigration status hearing. This led to the separation of families from children as parents were deported and children remained detained by the federal government. And this also included provisions that would prevent asylum claims from even being heard at all. These led to a series of protests and political outrage throughout the summer of 2018. Eventually, the Trump administration backed down on some of the zero tolerance policies. The Trump administration also led to significantly lowered the ceilings for refugees. In 2018, it was 45,000. 2019, 30,000, and the proposed cap for 2020 is 18,000. So there's significant decrease in the number of lawful entries for refugees and asylees. And additionally, in August of 2019, the Department of Homeland Security proposed a change to the interpretation of the public charge statute of the INA that would broaden the category of what counted as likely to become a public charge beyond direct cash assistance to include non-cash benefits, so enrollment in healthcare and food assistance programs, but also enrollment in there's language that would include enrollment of citizen family members in social service programs that they were entitled to as citizens. So if you are a legal permanent resident, but your children were born in this country, that you or if you had and you were seeking an adjustment of status, or if you were not a legal permanent resident and you were seeking a legal permanent resident visa, but you had citizen family members who were using public welfare provisions, that you could be inadmissible by virtue of your family members using their lawfully entitled social services, because that deemed you as likely to become a public charge. And many were concerned and are concerned that this will lead to basically a chilling effect on immigrant families refusing to use their lawfully entitled social services for fear that this could be detrimental for applications to citizenship, gaining green cards for family members, or getting an adjustment of status for themselves. So these were all different changes that were happening at the federal level under the Trump administration. So next class, we are going to be having our Current Events Friday, so that means that there's not going to be a video lecture from me, but you should post, if you still have current events due, you should post your current event post just as normal in the Moodle forum, just like usual, and then during the Zoom or Blue Jeans discussion section during our normal class time on Friday, we'll discuss current events. So especially, I encourage you, especially if you posted a current event, to try to join us as best you can for the Blue Jeans session so that we can talk about your current event posts. So there's no assigned reading for Friday. So for your discussion thread post for today, you have a choice. You can either respond and react to Nye's piece, The Strange Career of the Illegal Alien. What did you learn from this article? Did anything surprise you or change the way you think? Or more conceptually and normatively, how should we understand the relationship between the history of immigration restrictions and America's democratic and republican principles? Are these in conflict? Do they support each other? How should we understand this relationship? Remember, you have one post due Friday. That's a 200-word response to one of these discussion posts, discussion questions, and then a 100-word reply to a peer's post by Sunday at midnight. So that's it for today's mini lecture. Again, if you have any questions, concerns, drop into office hours, join the discussion section, or send me an email, whether it's a question about the material or concerns about accessing the material. Let me know what I can do. Until next time, stay safe, stay healthy, and take care of yourselves. Goodbye.